case on this morning's docket. That is case number 113302, State of Kansas v. De'Arian Potts.
May it please the Court, Samuel Shire of the Kansas Appellate Defender Office, appearing on behalf of the defendant appellant, De'Arian Potts. Your Honor, may I please reserve 3 minutes of rebuttal argument?
3 minutes is granted.
Thank you, Your Honor. The facts of the case are that my client, De'Arian Potts, was charged and convicted of vehicular burglary, severity level 3, criminal discharge of a firearm, and felony murder. Initially, he was charged as a juvenile, but he was later certified for adult prosecution. The facts underlying those charges were that one night, my client was driving a stolen car with 3 of his friends, Mr. Hale, Mr. Harris, and Mr. Hill. At some point, Mr. Hale saw a black Pontiac car drive by, and he said, quote, "There they go." Then he pulled out an assault rifle and began shooting at the black car. Mr. Harris and Mr. Hill, who were sitting in the back seat, started firing at the black car as well. My client, Mr. Potts, was not armed with a firearm. He was driving the car. The car that Mr. Potts was driving trailed the black Pontiac for approximately 1/8 of a mile. Eventually, the cars separated. The state sought a conviction for the severity level 3 criminal discharge and the felony murder based on the theory that Mr. Potts was aiding and abetting Mr. Hale, who was acting as the principal in this case. So with that in mind, I'll move ahead to the first issue raised in the brief, which is the sufficiency of the evidence issue with respect to the felony murder and criminal discharge charges. Because this is a sufficiency of the evidence issue, this court reviews all trial evidence taken in the light most favorable to the state, and then determines whether a jury could have found proof beyond a reasonable doubt that Mr. Potts committed the crimes for which he was ultimately convicted. And we believe that the problem with this case, as far as the sufficiency of the evidence goes, is really the timing of events. There wasn't any evidence at trial which suggested that Mr. Potts, Mr. Harris, or Mr. Hill knew that Mr. Hale was going to begin to fire his rifle at another car. There was just no evidence of that pre-planning. That's based on the statements of Mr. Potts, as well as the interrogation statements of Mr. Hill and Mr. Hill's testimony. And we do know that when Mr. Hale began firing, based on my client's statements, he appeared to be stunned. So when Mr. Hale initially started shooting, my client, Mr. Potts, was not aiding and abetting in any crime. If we look at the evidence taken in the light most favorable to the state, a jury could have concluded that at some point Mr. Potts began to intentionally follow the black Pontiac car and thus began to aid and abet.
Well, isn't there evidence that he actually sped up to get closer to the vehicle as the shooting was transpiring?
That's based on his interrogation statement.
And yes, and there was that. And then there was also evidence that I think Mr. Bradley, who was the victim in this case, who was killed, there was some shooting. The back window of the vehicle that was being shot at was shot out. And then sometime after that, Mr. Bradley says, "I'm hit." And then that's sometime after the initial shot. Why isn't that sufficient evidence that your client aided and abetted? Shooting starts, he speeds up. At some point, the back window shattered. Bradley proclaims, "After that, I'm hit," and then that results in the death. Why isn't that sufficient evidence of one, aiding and abetting at shooting at an occupied vehicle, and felony murder.
Well, Your Honor, first of all, I'm not sure there was clear evidence about when the speeding up occurred. And so what we have here is a situation where Mr. Hale got shots off. He was shooting an automatic weapon.
But in the light most favorable to the state, there's some evidence that that's what occurred.
Well, a jury would need to guess as to the timing of events. It's just not apparent at all from the trial evidence.
Can't you add to the facts that you had this, that one of the occupants of the car got into it with an oversized weapon? I seem to remember that in the facts, and I remember that being kind of persuasive to me that
Well, Your Honor,
that's a big deal.
Yeah, I believe the testimony was that the rifle in this case would have been approximately 2 feet long. And I believe that there was no evidence directly indicating that Mr. Potts was aware that that rifle was in his car. His interrogation statement indicated otherwise. But even if this court were to assume circumstantially that Mr. Potts knew that a rifle was in his car, you're not aiding and abetting in any crime by driving in a car with someone who has a rifle. And there was no evidence in this case that would allow a jury to make an inference that Mr. Potts was aware of any plans that Mr. Hale had to use that rifle and to fire upon another car. The evidence is just
weren't there
There's no
also-
direct evidence. There's no direct evidence. I mean, he's in the car with a big gun and his friends driving around. There's no direct evidence. They're all together doing this thing. They're all underage, or just he's underage? They're all underage?
Well, Mr. Hale was over 18.
Okay.
Isn't this the case? I may be getting my facts confused, but not only was the AK-47 shooter in the front passenger seat alongside your client, but there's evidence that 2 9mm handguns were also used to shoot at the victim's car.
Correct, Your Honor.
So could a jury have looked at the evidence that there's a driver of a stolen car and 3 of his companions get into the car with semi-automatic weapons, one of which is, I think you characterized as an assault rifle? A jury might say, well, that's a good starting point for us to figure out perhaps if there was a plan of anything besides going out to the dump and shooting rats. Is that a fair characterization or a conclusion for a jury to say this is not a good start? And then coupled with what I believe Justice Rosen was talking about, following this vehicle, and if you're totally surprised that the person next to you is shooting his rifle at the car in front of you, there's no evidence that he said, "What are you doing?" or putting on the brakes or swerving to avoid this, but perhaps not speeding up, but following the vehicle. I'm just trying to figure out what a jury would be making of just those facts.
Well, Your Honor, just to start with the evidence that obviously 3 people in the car were armed. That's just not evidence of a crime. People can carry firearms, and I don't believe that you are aiding and abetting them simply by driving people who happen to be armed.
But do you legally, do you have to aid and abet before the crime commences? We talk about during the commission of, and the crime here, the underlying crime was discharging a weapon at an occupied vehicle. And while those discharges were taking place, he aided and abetted with that crime during its commission. And I don't think the state had to prove which bullet was the fatal bullet. If he aided that crime during its commission and that resulted in a death, then that's the definition of felony murder.
Well, Your Honor, I would disagree with that, and I would say that the crime which resulted in a death in this case was severity level 3, criminal discharge of a firearm. a discharge of a firearm that results in great bodily harm. We believe that the evidence, even taken in the light most favorable to the state, would establish that there was an aiding and abetting of a criminal discharge offense that did not result in great bodily harm. In other words, that Mr. Potts would not have been aiding and abetting in a crime which caused another individual's death. It would have been the acts or the crime which occurred before he began aiding and abetting, which resulted in a death in this case.
So
How does
you're
that
saying
fit?
the underlying felony was a completed crime before the aiding and abetting began? Is that what you're arguing?
That's exactly it, Your Honor.
Excuse me.
Well, I essentially asking the same question because I'm trying to figure out how that fits with the rule we often state about the res gestae of a felony murder, which is a broader concept than it might be for some other crimes. And, you know, we talk about acts before, during, and even after the crime because we include fleeing from a crime in the res gestae of felony murder, as long as that's connected to the principal occurrence. So how does that work with,
Well, Your
what
Honor,
your argument is?
I think there's a distinction to be made between the res gestae of a felony murder and the res gestae of aiding and abetting. There is no res gestae aiding and abetting. So if you were to commit a burglary and you shot and killed somebody to enter into a house, that would be res gestae of the felony murder. And you clearly would have committed a burglary which supports the felony murder charge. What we're arguing in this case is that Mr. Potts did not aid and abet in a felony that supported the state's felony murder charge. So I think that's the distinction we would make to, I guess, the situation that you're discussing with res gestae.
So you're saying that if my aiding and abetting was related to the fleeing from the felony, or even in the I'm not sure. I'm not sure I understand how that still couldn't be aiding and abetting the felony murder.
Well, Your Honor, I don't believe that you can aid and abet a crime which has already been completed. So there's two things going on here. You have aiding and abetting culpability that you need to establish the commission of an underlying felony. And when you look at whether Mr. Potts aided and abetted in a severity level 3 criminal discharge of a firearm, we don't believe that that is what trial evidence establishes. And if he is not guilty of that crime, then he cannot be guilty of the felony murder charge, which is relying upon that criminal act
But
to support
don't
it.
we have some cases where, for example, the burglary has been completed, and that might have been the underlying felony?
Yes,
But we have talked about the death occurring during the post the completion of the burglary. As they flee, then somebody shoots. Again, it's that continuation concept makes this a little different, it seems.
I think that there's a difference between this case and the line of cases that you're discussing, because in the line of cases that you're discussing, there is evidence of an underlying felony. There is no doubt that a defendant committed the underlying felony, and then the timing of the killing doesn't have to perfectly align with the commission of the underlying felony. In this case, we don't believe that there's sufficient evidence of the underlying felony. And if there's insufficient evidence of the underlying felony, then there can be no felony murder conviction. I see that I've gone over.
I'm going to grant you your argument for the moment, at least, that the underlying felony happened right away, the first shots. And your argument is that your client didn't aid and abet those first shots. So I'm going to grant you that premise for the moment and then take you back to the actual evidence in the case. What, if any, was the evidence introduced that would have shown why or how these two vehicles came together on the street?
There really was no evidence Your Honor.
Nothing at all. The jury would have had no idea, and how these two vehicles came into close proximity to each other.
Yes, Your Honor.
And wasn't there some evidence that the shooter, I think it was Mr. Hale, made some comment before opening fire, something like "there he is" or "there they are" or something like that?
There they go.
Okay, there they go. Isn't it a reasonable inference to draw from that the driver of the vehicle had been looking for that car?
I think perhaps, yes, as far as the driver goes.
Okay, and your client was the driver. I mean,
Pardon
isn't
me.
that
I want to backtrack on that, Your Honor. I meant shooter. I misheard your question.
well? The evidence was that the shooter said, "There they go."
Yes, Your Honor.
I'm just asking, isn't it a reasonable inference to draw from that the occupants of the vehicle were looking for this other car?
I don't believe so, Your Honor, especially when the only evidence that tends to indicate whether there was any planning going on to shoot at another vehicle, all of it points in the opposite direction. And
I'm not asking about the shooting. I'm asking about how these two vehicles came into proximity to one another. And it just strikes me that the evidence is, the circumstantial evidence is such that a reasonable jury could draw the inference that these guys were out looking for that other car. And then you add to that the fact that it was an automobile that was loaded down with weaponry, and you get pretty close to, those inferences add up to sufficient evidence.
Your Honor, I would say that at most it would allow the jury to infer that the shooter, Mr. Hale, was on the lookout for a particular car. And the other thing I would emphasize is...
But that the driver had no idea. That's your argument.
At least there would be no evidence
Okay.
to show beyond a reasonable doubt that the driver had an idea. And just very briefly, the other thing I would note is that all of the surviving victims in this case testified that they had no association with the individuals in Mr. Potts' car.
It was random. The theory was it was random. There wasn't some beef. There wasn't some gang thing. It was random.
Well, I don't know exactly if it's fair to say that that's the state's theory of the case, but what I think would be fair to say is the motive for this shooting is entirely unclear from trial evidence.
Okay. And is there any evidence about the length of time that passed between the comment that Justice Stiegels made reference to, "there they go" or "there they are," and how long it took from that comment being made to the first shots fired, or how far the cars had traveled?
I believe that the indication is from the testimony that "there they go" is said, and then immediately
The shooting
afterwards,
starts happening.
shots start happening.
Okay. Thank you.
I have to tell you, counsel, if I'm driving a car and the fellow or woman in the seat next to me starts shooting at a vehicle in front of us with an assault rifle, and two people behind me are opening up with 9mm handguns, I don't think my first reaction would be, I'll keep following that car they're shooting at. My reaction would be, oh my gosh, what's going on? This is a terrible clamor in my ears. Is there any evidence of anything that happened other than your client continued to follow this car once the shooting started?
Your Honor, I believe the only evidence is that the car continued on the same path for approximately 1/8 of a mile, which would have been a duration of 39 seconds. But I don't think there's any evidence from which a jury could reasonably draw that immediately after the shots were fired, that Mr. Potts immediately decided to continue to driving behind the car. A number of shots would have had to have gotten off before Mr. Potts could have made that conscious decision.
According to the record, 31 shots, at least 31 shots were fired, because that's how many shell casings the police found. Is that right?
I believe that's the number of rifle shots that were fired, Your Honor. I believe it's 50-some total.
All right, thank you. Any further questions? Thank you, counsel.
May it please the court, the state of Kansas and appellee appears by John Gruby. The state generally agrees with the factual circumstances surrounding this incident. Mr. Potts picked up his friends in a stolen vehicle. They then drive around. They see a black Grand Am. The words "there they go" are uttered by Mr. Hale in
Was
this
there?
case.
I'll just stop you right there, and just because I just asked your opposing counsel about that, was there any evidence other than the fact that "there they go" was said that would have explained that to the jury, or from which the jury could put that in context?
There was really no evidence as far as why there was an issue with this Grand Am, other than they were armed. There they go.
So
shots
you
were
would
fired.
agree with, other than what we've talked about today, you would agree with your opposing counsel's sort of characterization that the motive here was, I think his use was a mystery.
I would say the motive was random. There's no other evidence for us to say that it wasn't random or possibly mistaken, but there's really no evidence that would clarify they knew them from a previous argument or they'd gotten in a fight at school or something like.
So the jury would just have to have heard "there they go" and drawn their own conclusions.
Correct.
Okay.
And this, the way I understand it is that from the time the shots start happening, the statement and the shots start happening, till the cars part, I think was supposed to be 1/8 of a mile, take about 39 seconds.
Correct.
And in that time period, the pursuing car hits a guardrail or the curb, but nevertheless continues forward following the black car, right?
Correct. I think.
And do we have any idea where in that 1/8 of a mile or how far into that 39 seconds hitting the curb or the guardrail happened?
I believe it's shortly before the pursuit ends. The vehicle hit a guardrail. The other vehicle then turned off, and it was over.
Okay, thanks.
Which lasted roughly 39 seconds from start to finish, based on the defense's expert. 53 shell casings were collected as a result of this, so it was a fair number of shots that were fired. I think that the evidence is sufficient to support Mr. Potts aiding and abetting this crime, based on just the timing, the number of shots that were fired, the statement "there they go." He then sped up to keep up with the vehicle.
And where does the
There's
speeding
evidence
up?
that he sped up. That's
Yeah,
what I
where's that
recall
come
from the record. Where is that, or how did you conclude
That's
that?
that is from Mr. Potts' statement. He told detectives that after the shots were fired, he then sped up
And what did he say? He sped up
to
because
keep.
he was frightened, or why?
He
did
sped up to
he
keep
explain-
pace with the vehicle.
He said that in his statement.
Yes.
Okay, thanks.
And I know that the defense's theory at one point was the actual murder occurred with the very first shot, and somehow that keeps Mr. Potts from aiding and abetting. However, there's no evidence that explicitly states that that first shot is the kill shot. Like we've stated before, it's 53 shots are fired at this point. If we view light most favorable to the state, any number of these shots could have been the kill shot.
And it seems that Mr. Bradley said that he was shot or I'm hit
Yes.
after the initial shots were fired.
Yeah, it's
And again, that would be in the light most favorable to the state. There's not conclusive evidence, but you can certainly glean that from the evidence.
correct.
I'm kind of curious, counsel, do you have an opinion on how far someone could continue to drive their car after they've been shot in the head with an AK-47? Would it be 39 seconds?
I would imagine no, it would not be 39 seconds. And if there's no other questions regarding the first issue, I'll go ahead and move on
Well-
to.
Was Bradley the driver of the Grand Am?
He may not have been the driver. I believe he actually could have been a passenger in that
I
vehicle.
believe he was a
Okay.
passenger.
All right, I thought he was the driver, sorry.
I believe that the car was eventually shot and was disabled because one of the shots hit the gas tank, and eventually the car was disabled through the actual running out of gas because a bullet punctured the gas tank.
how do you answer the second issue, that the vehicle burglary requires an intent to steal something besides the vehicle?
I think I would answer that in a way that you don't have to actually steal anything to commit a burglary. You can break into, whether it be a home or an auto, with the intent to commit a theft, and you still have committed burglary. Just because you are actually going to steal the car itself, I don't think that somehow gives you a pass on the fact that you were breaking into the vehicle with the intent to commit a theft. Now, the theft in this case was the actual car itself, but I don't think that somehow just because you are stealing a car, because that is what you're breaking into, that you're not intending to commit a theft. And I would say that the evidence is sufficient that that is what occurred, that he committed both a burglary by breaking into the vehicle and a theft therein, because he stole that vehicle. Regarding issue 3, which talks about the statement that Mr. Potts gave to detectives, I think it's very clear from the record that this was a voluntary encounter. He actually came to the detective bureau to speak with the detectives. He was not under arrest at this time. When we just look through the kind of a general Deno hearing as to admissibility, I think all of those were met. Even when we take maybe a more strict standard when we're dealing with a juvenile in this case, I think those were met as well. It's clear that his grandfather sat with him the entire time during this incident. He was given his Miranda warnings. There was no evidence that he was under the influence. It appeared that he understood. He didn't ask to stop. The general time frame was pre-interview and interview. The whole entire amount was...
And even before that, isn't there a problem that this was not preserved at the trial? That
There-
there was no objection to it, and then in fact, defense counsel utilized the statement in cross-examination and direct examination about facts from that interview
Correct.
for the defense.
Yes, and there was no contemporaneous objection at this point, and I believe it was brought up in a motion for new trial after evidence had been put on and after there was a verdict. I think it was brought up, but there was an issue of preservation just in addressing it. Even if this issue can be reached, I think that the proper procedures were followed. Even if this can be reached, I think it's clear that this was a voluntary statement after Miranda.
Was there a Jackson v. Deno hearing in this case?
I believe this was through a suppression. As how we've been
There was a
referring.
suppression motion.
Yes. And like I said, even when we're looking at the facts through Young, which is stricter, I think this is still applicable. And frankly, even without his statements, I think there's enough evidence that would make this error harmless. Evidence is clear that he was driving the vehicle. He then continued to follow that vehicle for 39 seconds after this all occurred. 53 shots were fired. So even if we, for some reason, didn't get this statement in, there would be sufficient evidence based on the facts of the situation that there could still be a conviction in this case.
The state has to prove, or opposing counsel says that argues that the state has to prove that not just that he aided in the discharge of firearms at an occupied vehicle, but the additional fact that it resulted in bodily harm.
Correct. Yes.
Which leads us back to, if the bodily harm is done before he starts speeding up, then that supports the argument by opposing counsel, right?
If that were the case, but I don't think that the evidence necessarily suggests that that is what absolutely occurred. I believe that's their theory, is that this the actual bodily harm occurred before the aiding and abetting, but there's no clear evidence that that is what happened. I believe that's their theory, but the evidence presented with the number of shots fired and the length of time, and just the totality of the circumstances in this case would give rise to that not necessarily being the case. As far as issue 4, which regarded failure to give an instruction regarding the definition of intent, this was also would have to be reviewed for clear errors. It was not objected to. Generally, a court must be firmly convinced that a jury would have reached a different verdict had that been given, and I just don't think that we have that in this situation. What we have here is, not to rehash the facts over and over again, but 3 guys get into a car with firearms. There they go. They follow them. They shoot. And this is all based on aiding and abetting. It was very clear from closing arguments the intent was the important part of what they were arguing. Both the state and defense counsel both argued what was Mr. Potts' intent here. You have to determine what his intent was. And furthermore, the jury instruction itself actually addresses intent. The crime intentionally aids another to commit a crime. We have another situation, or excuse me, another jury instruction that actually defines what an intentional act is. And I guess further, I would say that this particular instruction on aiding and abetting isn't actually the crime itself. This is explaining what aiding and abetting is. It's not really explaining the crimes that they've actually been charged. So I don't think that had that instruction been given, that there would have been any sort of a different verdict in this case. I still think that the jury would have came back with a guilty verdict regarding all counts just based on the amount of evidence in this case. Regarding the jurisdictional issue with whether or not this penalty was enhanced by waiving Mr. Potts to an adult criminal jurisdiction rather than trying him as a juvenile, that I don't think that's a violation of Apprendi, that somehow or another, just because he's being tried as an adult, that the penalty is enhanced. I understand that if you are being tried as a juvenile, there are certain penalties, and there are certain penalties as an adult, but those are completely separate issues. You have to have a complete separate hearing to determine whether he's going to be waived to adult jurisdiction. And at that point, once he is waived to adult jurisdiction, I believe if they wanted to enhance the penalty after that point, then it would be some sort of a violation of Apprendi if they didn't put on evidence of some sort of a aggravating factor. However, in this case, the issue with him being a juvenile is purely an issue of whether the court's going to exercise jurisdiction as a criminal defendant rather than as a juvenile adjudication. And I also think that the case law is fairly clear regarding that issue, and that the court has ruled in the state's favor and on that sort of issue. At this point, I would rest on the brief for all other issues unless there are other questions.
Any more questions? Thank you, counsel. Reserve 3 minutes for rebuttal.
Thank you, Your Honor. I would like to address issue 4 very briefly, which has to do with the failure to instruct on the definition of intentional conduct associated with the jury's aiding and abetting criminal liability instruction. I think as the state indicated, the key question for the jury in this case was whether Mr. Potts intentionally aided and abetted another in the commission of a crime. So for that reason, we believe that it was necessary to give the jury the definition of intent. And we would argue to this court that by not giving the definition of intent, the court failed to instruct on each and every element of a criminal discharge offense through a theory of aiding and abetting criminal liability which again requires that a defendant aid and abet intentionally. And I would note that our legislature has at various times defined the word intent or intentionally differently. So we don't think that it's the case that the word intent or intentionally has a common, everyday, well understood meaning. It used to mean essentially not accidental. Now, to act intentionally, a defendant has to have a conscious desire or objective to engage in a behavior or cause a result. So we think that by not including this instruction with the aiding and abetting instruction, it caused a serious constitutional problem. I believe that this court's case law indicates that if a jury instruction does not include each and every element of an offense, that it can only be clear error, or is clear error, so long as the error is not constitutionally harmless. And we don't believe that in this case the state has established constitutionally harmless error, and for that reason we would ask this court to reverse Mr. Potts' convictions.
Any further presentation?
Not at this time, Your Honor.
Any questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.